Alright. Hello and welcome to the latest legal trends impacting your agency webinar presented by Polsinelli and CareTime. Today's webinar is being recorded and will be available for replay within 5 business days on our website. Please use the Q&A box to submit questions to our speakers throughout the webinar. If your question is not addressed live, one of our speakers will contact you directly following the webinar. If you experience any technical difficulties, please type your question in the chat box and our engineer will assist you. I will now like to turn our webinar over to our CareTime partner, Scott Sauerbier.
Thanks, Kendall. Thanks everyone for taking the time out of your busy day to join us. At CareTime, we pride ourselves on providing you a software solution you can actually enjoy. Angela, if you'd be so kind, thank you so much. Growing your agency while adding new caregivers and often staff is often challenging enough. Your home care management software shouldn't be. Allowing your team to get up to speed quickly will be essential during their onboarding. With our CareTime Academy, each user can earn their own certificate of achievement, demonstrating their new skills and helping you, the agency owner, the manager, to become more productive. With our trusted connected care service partners, as displayed on the right side of your screen, which aptly includes Polsinelli, we work to seamlessly integrate these into the CareTime software. Compliance is always top of mind, so when you're using CareTime, you'll always have the peace of mind knowing that you're using the most up-to-date solution on the market. If you are new to CareTime and you'd like to learn more, feel free to contact me. If you are already a CareTime customer and like to learn more about our connected care service partners, feel free to send me a message as well. Thank you for allowing CareTime to sponsor today's webinar with Polsinelli. Angelo, over to you.
Thanks very much, Scott, and really appreciate you sponsoring this webinar and giving us the opportunity to visit with all of our friends in home care. Good to see you all. I was taking a look at who's registered. A lot of close friends and great clients, and just want to remind you all how much we love you and appreciate what you do. This is a real passion of mine, a real privilege and blessing to be able to serve this industry. I think it is truly God's work. You've heard me say that before, and it's a wonderful, wonderful time to be in this industry. There's so much going on and so much excitement around it. And I think everybody understands that care needs to be in the home. We've got the technology. I just got back from the innovation forum with a lot of the leaders in this space. It was great just hearing about what is coming down the pike and some of the work that's being done from an advocacy perspective to really help us with reimbursements and with putting money where the mouth is when it comes to the idea of aging at home, which everybody wants. So we just now need to make that a reality and make that affordable for all. So if you don't know me, I am an attorney. Don't hold it against me. It's just what I do. It's only a career. It is not a personality flaw. I work for the law firm of Polsinelli. We are a national platform. We do everything, everything, and the firm is designed and built around this industry to service this industry and be a one-stop shop for all legal services. We are going to talk today a little bit about what is happening with respect to federal agency enforcement generally, looking first at the FTC ban on non-competes, proposed ban, and a status update there. Some of the government investigations we're seeing related to the COVID relief programs and the Department of Labor and how active they have been in recent times in targeting home care agencies. And we'll also talk about how to best protect the business before the DOL or a plaintiff brings a lawsuit. So let's just jump in. We only have a little less than an hour today, so I want to make sure that we have an opportunity to get to any questions that you may have. Please feel free to use the Q&A feature. There's a chat feature and a Q&A. Q&A is where you want to put any questions you have, and we'll reserve a little time at the end to get to those. It is a big audience today, so get your questions in early if you've got them, and if we can't get to them all, we'll do our best to follow up with you after the fact. Okay, so let's start with the Federal Trade Commission's proposed ban on non-competes. Likely you all have heard about this already, but let's just start with kind of the base, the ground rules here on what, when we're talking about a non-compete, what does that mean in comparison to some of the other restrictive covenant agreements, right, that we hear about, like non-solicits and confidentiality and the like. So the idea of a non-compete in an employment setting, sometimes you have non-compete agreements in a business-to-business transaction when you buy an agency and you lock up the owner or something like that. That's beyond the scope of what we're doing, what the FTC is doing here. Their focus is on employee agreements. And the concept is that an employee would agree, and this is generally, you're looking at generally a higher level employee. So an executive level employee, maybe your head salesperson, administrator, somebody at that level would be restricted based on a non-compete agreement from working for a competitor and working for a competitor doing the same job. So non-competes generally are limited, not only to the executive level, but also by geography, with a very narrow geography that is tied to the business, right? And not just the business. So for example, if we're talking about Gentiva or Aviana, you wouldn't have a non-compete that restricts the executive across all branches. It would be where the executive, where they actually operated, right? And where their region is and influence of control. The time periods are normally limited. You see time periods at maybe as little as 6 months, a year. 2 years is probably at the outside. After you're getting past 2 years, it's probably not narrow enough for it to be enforceable. And again, it's limited to the same type of work that that manager was performing at your organization. Good work, guys. I already see a couple of questions. So you know what I'll try to do is take some of these as we go as well, since we're on the topic. So I'll get Connie to you and Adam to you here in just a second. So a non-solicit agreement is, now this isn't a type of agreement that you can use for the majority of your workforce, and you're not restricting that workforce from working elsewhere, but what you're restricting them from doing is soliciting your clients, your customers, your employees, other caregivers, for example. You're preserving confidential information. And this is actually a good idea to utilize these kind of agreements with the majority of your workforce so that you can protect your business. And what courts look for is they look to determine, when they're analyzing a non-solicit or a non-compete, is that agreement designed to protect the business, or is it designed to restrict worker mobility? And the more across the line towards worker mobility, hey, you're affecting that person's ability to have a career in the area or the industry that they have experience, that's more likely to be less enforceable than, hey, you're just trying to protect your business interests and make sure that what you have built within your organization remains within your organization. And that's why a non-solicit can be broader and is generally more enforceable than a non-compete. Does that make sense? All of these laws, by the way, are state laws, state-driven laws. Sometimes we see particular legislation or law only targeted towards our industry, but it's still state law. An example of that would be Connecticut, and Connecticut having a very, very restrictive view on non-competes, which would even include a direct hire provision, which we'll get to in a minute, only within home care. So you can have an agreement in a different industry that would be enforceable, and it's not enforceable for the home care industry. But it's always state law. And so this is really kind of, and this map is sort of showing you where the laws are, and you can see, so if you were just looking at an industry map, then Connecticut would also be pink, where non-compete agreements are banned. The reason it's not is because, again, they're not banned for other industries. But the law it varies quite a bit based on what state you're in, and some non-compete bans are only for a certain level of employee, like a non-exempt employee or an employee that's earning, less than a certain amount of money. But it's always state law. So the idea of the Federal Trade Commission getting involved and banning non-competes is really, really astounding and quite a change from the norm, and will result in a lot of litigation. But I'm getting ahead of myself a touch, because first you got to know, is this rule going to go into effect, right? That's what everybody wants to know. And the answer, I believe, is yes, it will. Yes, it will. The FTC will issue a rule, and that rule will ban the use of non-compete agreements across the country. Not only will it ban non-compete agreements that are prospective, but it will most likely invalidate all non-compete agreements that have already been signed. That's even more amazing to me, because oftentimes companies pay significant consideration for that non-compete. So they've already written the check to an executive, let's say it's a CEO, provided the CEO with all the secret sauce, and now that CEO's non-compete will be unenforceable according to the FTC. And what happens from there, and the reason I say it's very likely that the rule goes into effect, is because it's what Biden wants, right? That's what Biden has asked for, and he's asked the FTC to look at it, right? Not Congress. So this is not a legislative, a piece of legislation where you've got lots of votes. It's going to be up to the FTC whether the FTC issues the rule that the FTC wants to issue. So what do you think the FTC is going to do, right? If you wanted to go eat some McDonald's and you were the only decision maker about eating some McDonald's, are you going to eat a Big Mac? Probably so, right? Unless it's chicken nuggets. So that's what's going to happen. And the real question is what happens from there, and will the FTC be overturned by the courts? And now I'm predicting a little more, something that's a little more variable. My guess is, and it's just my opinion, not the opinion of Polsinelli or anyone else, my guess is that ultimately the challenge against the FTC, which is probably going to come from the US Chamber of Commerce and other associations, it ultimately will be successful, because the FTC is really, really extending, in my view, beyond the authority that they have. And number one, it's a state right to begin with. And if it wasn't the states that are dealing with non-compete law, then it should be Congress, not a branch of, a part of the executive branch, right? Without all the proper checks and balances. So that's my view. And when the challenge comes, they'll be seeking what's called an injunction, and they'll ask for the court to stop the rule from going into effect. So as soon as it's published and it goes into effect, they will try to stop it from going into effect. And what happens there is critical, because we're going to be in litigation for years over this. And if the injunction is granted, then it'll be sort of business as usual, but for whatever period of time existed between the rule going into effect and the injunction. But if there is no injunction, then this is going to be the rule for a while until there's a decision from the courts. And again, if I'm wrong and the courts say the FTC can do this, then they're going away, right? Non-competes are going away. So it's a little bit of an uncertain time. I'm going to be up in Chicago with Lincoln talking about some of this stuff at their HI Squared conference next week, because what we think it will happen is there'll be a big shakeup at the executive level across a lot of these brands, right? Where, for the window of time when there are no non-competes, some talent might move from one big brand to the next. The other impact that's very, very significant here that is unique to this industry is how this law will be interpreted for purposes of penalty provisions or direct hire provisions in client service agreements. And this is what we've been working with a lot of you on the call on is updating your client service agreements to change, modify what would typically be a penalty provision. And what I mean by that is you are saying to your client in your client service agreement, you can't hire my caregiver that I introduced you to away from me without paying a penalty. Some states disfavor that kind of provision. Connecticut is a very good example of that. What I was saying before, they say those type of provisions, even if they are direct hire, are not valid. In contrast, when you look at other states, they don't like the penalty provision where you're saying it's a penalty and it can't be done because they look at that as another version of a non-compete. They say, well, you're not allowing that caregiver to work for who the caregiver wants to work for. And what we're saying is, no, we're protecting our business interests. We're the ones that were responsible for making that introduction. If we can't protect our business interest and be reimbursed appropriately for all the vetting and training and everything that we've done for the caregiver, why are we in business? You're going to force the vulnerable sector of our population, the elderly, to hire off the gray market without any supervision and training because you're cutting the agencies out of the deal. And that's the conversation that's going on right now with the California DOJ and with the government in Illinois and some of these other states that have restrictive views on those provisions. But what I would tell you, the practical tip for you as the provider is that what you should do in every state other than Connecticut, right, which is, in Connecticut, this won't even work, this modification, but instead of treating your penalty provision as a penalty provision, make it an alternative to your services. So think of it as a placement fee instead of an hourly charge that you have when you're billing the client. So hey, instead of me charging you this hourly rate, if you want to hire this caregiver, we're not restricting you from doing that, but there's a lump sum cost, and that goes instead of in the bottom of your agreement, like a punitive damages type clause, put it up in the part of your agreement that talks about what the terms of service are, and also include an attorney's fees provision that will allow you to collect attorney's fees if you have to enforce that, just like if you have to get them to pay you for the other services that you're providing or the other mechanism by which you charge by the hour, right? You would have a legal remedy to collect the money that they contracted to pay you. And we've got language that we've crafted in each of the states, right, that we think is effective, and we're actually sharing that language as appropriate with the governments, right, that are educating them on how our business works, and trying to get them to bless some of this language. And what we're telling them is, look, you can go and investigate companies and do this piecemeal. We work with thousands of home care businesses, and if you will give us language that we can all agree on is reasonable and protects our interests, we'll help you. We'll help you get it out there by working with our clients and modifying their agreements. So win-win for the government. That's been effective so far. All right, let me stop. We've got a bunch of questions already, so let me stop for a second and just answer a couple. The one question is, do we need to replace our old or current non-competes out there with our current employees? Well, what will likely happen if the FTC rule goes into effect and is not enjoined, is not stopped, you will actually have to notify any employee that you have a non-compete with, that non-compete isn't valid. And it doesn't apply to them, the non-compete portion of it. But if you haven't had your non-competes reviewed in a while, the law has changed very, very rapidly. And the way that the pendulum is swinging, it's more and more and more restrictive, meaning that your agreements are more and more and more likely to be invalid. So that's another tip that I would give you is that you really want to focus a little more on the carrot. You know, when we're thinking about caregivers and retaining your staff, incentivizing them to stay with you as opposed to trying to prevent them from leaving through restrictions, restrictive covenants. But that's an overarching picture. You know, there is a time and there is a place for non-compete. It just has to be really well thought out and narrowly tailored to your business and to your situation. So if it's been a while and you're kind of using a form and having everybody sign the form, you know, that's not, you know, that's, and that form hadn't been looked at in some time, that's probably not the way you want to go. One more question, we'll get on that, and then we'll jump into government investigations, which I know is going to, this is going to raise some eyebrows. As an alternative to a client agreement to not compete, can we instead have an employee policy that states that you cannot work outside of, I won't say the name, company, agency, and or resign and work for clients you met through company? So that's really, you know, my view on, you know, sort of a non-compete or restriction on a caregiver is that it's really not worth it. We enforce these all the time, right? The direct hire provisions, put them in your client service agreement. That's where they belong. Trying to restrict or directly contract with a caregiver who is already working for multiple platforms. And I understand that question. It's the question of, hey, all we're trying to do is keep that caregiver from going offline with the client, right? And disincentivizing them from stealing our client, our direct client. It's challenging though. And the reality is you're not going to try to enforce that against caregiver because caregivers don't have any money, right? They don't have any money to pay you. So if you want to do it as a prophylactic measure, I'm not going to, you know, it's your business, but I highly recommend you just focus on the client side and not worry too much about the caregiver. You know, it's very likely, and I don't know precisely what state you're in. Again, there's some states that that are easier than others, where you probably could get away with something like that. But generally, I view the juice is not worth the squeeze. Okay, let's move on to this. And I know there's some other questions that I'll try to get to, but keep them coming. The PPP program, EIDL, and ERTC, and I'm going to focus mostly on PPP and ERTC because I think those are the most common. But both PPP and EIDL, recently, there was an extension of the statute of limitations to prosecute investigations and claims around PPP fraud, EIDL fraud, and there have been several investigations. Those investigations have been generally focused on low-hanging fruit, those who are really clearly utilizing funds for fraudulent purposes or creating companies that don't really exist or companies that went out of business, but there wasn't a return of the money. But there are many, many more investigations on the horizon, and the government is using really sophisticated techniques to identify using AI and using cross-agency collaboration to investigate just about everything. And it's a 10-year statute of limitations for those two programs. You all are familiar with the PPP program. So I just want to kind of cover the highlights of what exactly is being investigated. So what the government is looking for is they're really looking for, it's not so much the application process on PPP as much as it is, how are you tracking the use of the funds, right? Were the funds used for appropriate purposes, maintaining payroll, hiring people back, right? Covering that the business cost overhead that were designated through the program. That's what you really need to make sure that you can demonstrate, right? That you utilize the funds in the right way at the right time. You do want to keep all good records of your applications and your qualifications, but the focus by the SBA has really been much more on the use of the funds. And the other thing I will tell you is if your aggregate PPP loans were under $2 million, the likelihood of you being audited is significantly less If it's more than $2 million in the aggregate, it's a virtual guarantee that you will be audited. The government has said that they will audit each and every one of those loans. That may not necessarily get to you on your radar because they're starting with the banks and looking at the banks and using some of the techniques that I mentioned with AI on the bank application process, and then taking certain loans to a second level. But that's what you really need to be more focused on, is how you spent the money, making sure now that you've got all the supporting documentation and you've got all that in a file, because you can't assume that your compliance officer or whomever was responsible for monitoring that program is going to be around in 10 years and is going to be able to say what happened in 10 years ago. I couldn't tell you what I ate for breakfast yesterday. So the idea of somebody being able to provide the supporting evidence 10 years from now is more than challenging. So just get all your ducks in a row now and be ready. If there has been any problem, by the way, with you getting loan forgiveness, you should talk to us, because our finance team, the finance lawyers, have been very successful in challenging the failure to forgive successfully. And if you get even your bank starts asking you questions, that is a likely fact pattern that means that somebody's asking the bank those same questions, right, in an investigation. So contact your attorney when that happens. Let's turn to ERTC and talk a little bit about this. Most home care agencies have qualified for the employee retention credits or employee retention tax credits by the government shutdown, right? It's an either or. Either your revenue dropped, and some have met the 20% requirement from 2021, but the majority, they're relying on having been directly or indirectly impacted by a full or partial government shutdown. That's how they're doing it, and there's a lot of money to be had in this program. And the program, I think, has been employed in a much broader fashion than the IRS ever contemplated. I think if the IRS had a mulligan to do it over again, they probably would, right? They would craft this program differently than they did, because it turns out that the majority of home care and home health agencies weren't adversely impacted that negatively by the pandemic, yet they're getting, hundreds of thousands or millions of dollars, from the ERTC program. And the argument that you're making effectively in doing that is that your revenues would have been higher but for these government shutdowns. But the key here to the ERTC program, and what has happened with the IRS, just like the PPP statute of limitations went from 6 to 10 years, the IRS moved the statute of limitations from 3 to 5 years to conduct investigations. And they've been very open and vocal about the fact that they are going to be auditing businesses, right, carefully, and looking, by the way, specifically at some of the vendors in the space that are charging a percentage, right, of the overall credit that you're reimbursed. They're going to look very closely at those kind of businesses. So the key for you as an employer here is to make sure that you can demonstrate that you had reasonable, when you applied, or if you're going to apply, reasonable anticipation that you would get these ERC credits because you in fact qualified under number 1 or number 2. If you believe that you were going to qualify under number 1 and it didn't happen that way, you want to make sure that you've got your ducks in a row to show why you thought that. By the way, because I'm a lawyer, because I know that means that I've already got one hand tied behind my back as far as my reputation. Hopefully you guys know me by now, know that I'm not lying to you, that when I tell you something, that it really is something I think you should do. My role as the industry attorney is to look around the block, right? Tell you what's coming down the pike before it comes, so and you're prepared before it ever happens. That's whole platform is what we're doing, because the same thing happens on repeat over and over and over to you, but it's often a surprise to you because you haven't individually experienced before, but all of your competitors have, or your colleagues or your peers, as I prefer to say. So you see here, the IRS has said, you know, hey, we're warning you for the second time, right? To be careful about these businesses that are qualifying people for the credit improperly, right? And it's talking about, this is very small, but it says these promoters charge a large upfront fee, or a fee that's contingent on the amount of the refund, right? And it goes on to say this is a warning that, you know, if that's a scheme, if they're not properly vetted and qualified, right? And the point that the IRS is making is that these vendors are out soliciting, and again, as long as, you know, they are the right platform, that's not necessarily an issue. But if they're, you know, because they're financially incentivized for you to qualify, you know, are they qualifying you appropriately? So you really, really want to closely vet those kind of programs. And my advice is, for your documentation, actual documentation of your qualification for the program and that reasonable anticipation standard, do not rely on the vendor who's qualifying you to be the one to say that you're qualified, right? Use an outside source, and use a source that has the proper credentials to be able to help you to do that, utilizing evidence about your business and the impact that government shutdowns had on your business, as well as what those shutdowns were, and tying each shutdown to each quarter in which you claimed the credit, right? And having that kind of preparation is essential, or extraordinarily helpful, if and when the IRS comes. So this is sort of a little takeaway. And we've got a tax attorney that does a ton of that work. He's worked with a lot of you in helping you develop that evidentiary fact record that's independent of whoever it is that helped you with the qualification, whether that's your own accountant or one of these vendors. And there are some businesses that are using their accountant, right, who is charging them by the hour rather than you know, a high percentage. And yeah, that's certainly a possibility too. So you just want to make sure, and I'm again not suggesting that if you haven't applied that you don't apply, or that if you have applied that you're in trouble. All I'm saying is really make sure that your house is in order. And if you run into a problem where it looks like, hey, you know, we might have jumped the gun here on PPP, or we might have jumped the gun on the ERTC, there are things you can do to fix that, right? We saw what the Lakers did, right? They gave their money back, right? So you can do some things proactively to keep off of the government's radar if you have some concerns about, you know, how you went about it. So make sure you've got your record in place now, okay? Make sure that you've got all the documentation that you submitted to lenders, right? Each program is a little different as far as what you need to do, what your records need to be, but one of the critical aspects is tracking, especially on PPP, tracking how you were using that money and being able to demonstrate, I got this money in and it went out for these purposes. Okay, so if you haven't done all that, get back to it and do it. I don't know, Kendall, if we can add this link to the chat or Q&A, but we wrote a very nice, comprehensive white paper on all of these topics that tell you what you need to do, and you know, what the statistics are, and you know, how to really comply with each of these three programs, and the provider relief fund as well is in here. And Kurt Erkstein is he is a attorney that's a white collar lawyer. He actually worked with the government, right, prosecuting businesses before he came over with us. So he's got a really unique perspective on what's going on, and it's a great white paper. If you haven't seen it, it is free. So download it, read it, and follow those steps. All right, let's move on to the Department of Labor. A lot of questions coming in, so I can already tell that we're probably going to have to follow up with some of you, but keep them coming. and we'll do what we can. DOL, very, very focused on home care. Here's why, right? Look at these statistics. This is one of their press releases. Every time the DOL comes in and they get a significant back wage award, whether it's a settlement or a lawsuit, they typically will publish something about it, and it can really do some damage to the reputation of a business. So when you get a DOL audit, this is one that you really want to make sure that you have counsel for. You know, when you're dealing with the IRS, you know, you can typically work with an accountant for things like that. Unemployment claims you can generally do on your own unless it, you know, it's significant or has a significant impact on something. You don't typically need a lawyer. My view is when you're dealing with the Department of Labor, you really should have qualified counsel helping you. And when you look at these penalties and the recoveries, 28.6 million over the last couple of years, right? Just focused on, this is facilities and home health and home care services. And what the DOL concluded was that 80% of those organizations are out of compliance. When you focus specifically on only nursing homes and home care, that number goes up to 89%. Okay, and one of the reasons I like to demonstrate this or show this is one, where do you think you are? You know, are you in the 11% or are you in that 89%? Right, the odds are not in your favor. So get your house in order now. Don't wait for the Department of Labor. Don't wait for a plaintiff's lawyer to come after you. And two, this is why, folks, this is why the DOL is so hot and heavy on home care, because every time they come and look at us, yeah, they're finding a violation. So the belief at the DOL, and this has been the belief for several years, is that the home care industry is not compliant and we don't pay our people the right way. And so they have to step in and protect these workers where the organizations are not. And that, my friends, is exactly why we are doing what we're doing. We want that perception to change. That's not a reality. The reality is it is difficult for you to be compliant when you're dealing with a almost exclusively remote workforce that's paid multiple wages, right? Multiple rates that, you know, sometimes have meal, travel obligations, you know, reimbursement requirements, right? For mileage, meal and lodging, right? It's challenging. They live where they work in some cases, right? It's a challenge. Yeah, there's pay per visit when you're talking about, you know, home health, right? Day rates, these, you know, a traditional way of doing things that is no longer the way. And we just need to be very, very diligent in our own house and not be that low hanging fruit that the DOL can continue to target, because that's what's happening right now. The DOL has also announced that they're really focused in on the South, right? Looking at businesses in the South that generally are not represented by unions, have fewer labor laws, right, than the Northeast or the West Coast, right? So the focus and generally lower wages, right? So the DOL, we're seeing more and more investigations. I probably have 6 or 7 investigations active right now in Florida alone. You know, Florida has always been a hotbed, and more in the South. So if that's where you are, be ready. How do you get ready? All right, let's first talk about what to do. Let's say that you don't heed any of this. Well, even if you did, right? This is universal, right? Whether we feel like we are compliant or not, right? Yeah, what I would recommend taking a step before this one. You know, work on your compliance now. Do a health check, an internal health check. We can spend a couple of hours with you on the phone and tell you how you look, right? Just by asking you certain questions, right? Looking at your handbook, looking at the agreements you have in place. Let me see your offer letters, or just talking it through. You know, where are your risks in your state? What are you doing, right? This is our expertise. We can help you get ready for this scenario. But whether you do that or not, when this happens, when the DOL comes, this is not an exaggeration. This dude here, right, he looks a little intimidating. He's got a badge. That's what they do. They flash a badge. They tell you that you're under investigation. It scares the bejesus out of whoever is working, your receptionist or whoever that is. And because of this situation, they feel that they need to respond immediately and share whatever information that investigator is asking for. And these investigators understand that and will leverage that. Okay. And they will ask for you to do things immediately. You don't need to do that. They'll ask you to produce things. They may ask to conduct employee interviews right then and there, right when they arrive. Yeah, and sometimes they're calling, sometimes they're showing up in person. You don't need to do any of that. So here are the operative words that you want to make sure that your staff is trained to tell that investigator when that investigator arrives is, this is not a good time for us. This, you being here right now and conducting an investigation on the spot is an interruption of our ordinary business. It's an interruption of our business today. It's not a convenient time. I will get to the owner. I'll talk to the owner or whomever, the CEO, our attorney, and we'll be in touch and we'll help make sure that we can coordinate this at a time that's more convenient. Get your attorney involved, and this is not your family attorney, right? This is not your general attorney, an employment attorney. Get an attorney that knows this industry involved right away. The DOL is going to look at everything. It's normally, the investigation is normally driven by a complaint. But once the DOL is there, they're going to look at everything. They're going to look at your exemptions. Is your office staff exempt, truly exempt? If you're classifying them as exempt, do you have independent contractors? That's been a huge focus of the DOL. I don't know if you all saw the recent press release with the Pennsylvania provider that ended up paying over $7 million to the Department of Labor in back wages. They will look at FMLA compliance. They will look at on-call practices. They will look at travel time, business reimbursement, cell phone reimbursement, minimum wages, overtime, live-in practices. They're going to look at everything. Regular rate. Are you including bonuses in the regular rate? Are you calculating overtime using the weighted average? They will look at everything. So you need to make sure that you're prepared, and as much as you possibly can. What folks really don't realize about the Department of Labor is that the Department of Labor, it's a negotiation. It's not a set rule. They'll have a set letter where they hand it to you and they say, we want your tax returns. We want 2 years of your payroll records. You know, we want your firstborn child, right? We want to have your molar teeth, right? They're going to ask you for everything, but then you work with the DOL. And this isn't an adversarial thing. We have got, good relationships with the DOL. I would much, much rather see the DOL than a plaintiff's lawyer. But we got a solution for the plaintiff's lawyer too. We'll talk about that. You guys have heard me talk about that. Arbitration agreements. That is the kryptonite. That is the garlic for the vampire, right? That's the stuff. That's the program you need to have to protect yourself from class action lawsuits. Everybody needs to have that. If you do not have a arbitration program, we absolutely need to talk. We need to talk. And if anybody's told you not to have an arbitration program, let me talk to that person, because that's wrong. And I can give you a million war stories as to why, but that's not the subject matter of today. My point, though, is that you develop a good rapport with the DOL auditor. A lot of times we already know them. Say, hey, look, we've been working with this client for a long time. We've already been through this drill. What's going on? What are you actually looking for? We know that there was a complaint. You're not going to tell us who's complaining, but we think it maybe was this person. Yeah, this is what happened with that person. This person was paid appropriately. Nothing to see here. Sometimes we can get them to go away. If you're using our compliance materials, by the way, we had a client where the DOL is a California guy. DOL comes in, looks at the policies, which are the policies we drafted for him, and the payroll records. It says, yeah, I'm not going to do this investigation. Turn around and left. Like, these are some of the best policies I've ever seen in my 20-year career, where I can see that you have your house in order. We don't need to investigate you. Literally, that happened, right? There's a lot of things you can do to protect your business and to limit what the DOL has access to. The more they have access to, they don't need your tax returns. We can stipulate the reason they're asking for tax returns is so they can demonstrate that they have jurisdiction. We can stipulate to that and say, we don't want to produce tax returns. We don't, the DOL works with the IRS. We don't want them to have your tax returns, right? If we can avoid it. So we're going to limit things. We're going to make sure that we document anything that we've done right, right? We're going to limit the on-site. They're always going to do an on-site. We can sit with the management employees. We can prepare management employees before they talk with the DOL, help them to understand what the DOL is going to ask and look for. There's a lot of things that can be done to truly move the needle. If there is a problem, we can fix the problem while the investigation is going on, right? And garner favor with the DOL and cut off damages by doing that. So there's a tremendous amount of strategy that goes into a DOL audit that you shouldn't be trying to do all by yourself. Or it's many times, we had a client reach out to us from New Jersey recently after the auditor came back and said they owed $500,000. Said, all right, we need your help now. Well, now it's a little late. It's going to be really hard to put the toothpaste back in the tube in a scenario like that. Okay, last segment, and then we'll get to questions. Let's put this all together and talk about, all right, we're talking about getting your house in order, talking about all these issues, everybody poking at you, right? The government, the DOL, the plaintiffs' lawyers, right? What do we do? What do we do? And I know this can sometimes feel overwhelming, especially on a really short webinar like this, right? Where we're going a million miles an hour and throwing a lot at you. So I just wanted to say this, two things I'll say. The first thing is, if people aren't suing you and the government's not coming after you, then your business isn't worth enough, right? Think of it that way. The silver lining is you've got something of value that other people want, right? That's why they're looking at you, because you've got something that's worth something. And anytime you have something that's worth something, people are going to want a piece of it, right? So don't think of it as such a negative, horrible environment. Think about, hey, you're successful and you're growing and your business is going to continue to grow. And you're in, the opportunity of a lifetime in home care that is now becoming the golden child of healthcare, right? You're in it. So you protect yourself now. Get ready for the future, for all the success and growth you're going to have, and build your platform today so that you can expand and not have to go back and fix it, right? And by the way, if you ever want to sell your business, right, when you're ready to sell, this same process that we're talking about, you're going to deal with me sooner or later, right? I'll be representing the buyer, and I'm going to come, unless I'm representing you, right? I'm going to come and kick the tires and say, oh, you're not doing living the right way. Here's a problem. You're going to have to fix it anyway, and now it's going to affect the enterprise value of your business. Or you're going to have an escrow set up, right? Because there's a potential $2 million in liability that has to burn off over 3 years, right? So and I'm not saying me personally, it might be me, but somebody's going to do that, right? Any business that's worth something, and the reason for that is there's successor liability, right? These issues that we're talking about, whether it's an asset deal or a stock deal, it doesn't matter. The buyer assumes that liability as soon as they assume your business. So they're going to look very carefully as to what policies you have in place, what your practices are, is there liability, right? On the healthcare regulatory side, from licensures, quality of earnings, and all your legal compliance. That's a big thing. That's one of the things we do more than anything is looking at these transactions and either preparing the seller or representing the buyer at the time of the diligence. So be ready, and so understand, right, that the presumption when it comes to pay practices is always that an employee is non-exempt, meaning they're entitled to minimum wage and overtime. And if you're going to establish that they are exempt, that's your burden and responsibility, and you've got to have the right resources, materials, job descriptions, everything, right, to be able to establish that. And there's no way to get out of these laws. You can't have an employee, sometimes it's your employee that is willing to be the most accommodating that creates the biggest problem for you from a compliance perspective. You don't have to pay me for coming in early. You don't have to pay me for looking at the care notes just to get ready to service the client. I'm doing that for myself because I want to be a great caregiver. Wrong. You do have to pay them for that. You do have to pay them once they work more than 40 hours. You have to pay them overtime, even if they would agree to straight wages and say, you don't need to pay me overtime. I'll sign a document saying you don't pay me overtime and we're good. They sue you the next day, they win every time, or the DOL finds about it, even though they don't want to pursue you, and they represent that worker and make you pay not only what you should have paid, but double what you should have paid, right? And if it's a plaintiff's lawyer, it's probably more like triple what you should have paid. So do not try any side deals with any employees, and then you need to make sure that you are monitoring. You've got to be like Big Brother. You've got to be on them. You've got to know where they are, know what they're doing. There shouldn't be any assumptions as to, well, are they taking their meal? Are they getting their sleep time? Are they tracking their travel? We don't really have visibility into it, but we assume that they'll tell us if there's a problem. That's not sufficient. You have to know, and you have to have the records, right? And work with folks like Scott, right? To make sure that you've got the systems in place, right? To be able to see and observe and know where your employees are. So one of the things you're going to look for are gaps, right? Where is there a gap? Where is there the potential that somebody's working and I don't know about it? This starts with your policies. That is, your policies are the backbone of your organization. You need the policies. We just talked about assumptions. A very robust complaint and investigation procedure for when we do have a problem, right? We need to have the employee with an open door to you or your human resources. The number one reason that employees sue their businesses, the companies, and go to the Department of Labor with a complaint or go to the lawyer with a complaint is because they don't feel they have a voice within inside their organization. If you can make it very, very clear through your complaint and investigation procedures and policies that we take compliance seriously. We want you paid for every hour, every minute that you're working. And if you have a problem, if a supervisor has ever told you not to record your time, or you think that there's something inappropriate, we want you coming to us. We want to address it, and we will address it. Man, the companies, I've got companies that are, I was just with somebody earlier this week. I won't say his name, although he might like me to. It's a $30 million business in the Northeast where there's a tremendous amount of litigation. He just doesn't have problems. He doesn't have problems. He's my worst client. Yeah, I talked to him, for free at conferences. That's it. Every once in a while, ask me for a tax memo or help him with a license. But he's a terrible client because he's so compliant. He's so good. But it's not just his compliant program, his compliance. It's his culture, and that his employees know, right? And it's not just him. Obviously, it's a big company, but they know how to address concerns. And when you look at his EEOC charges, his lawsuits, it is a fraction of what a normal business that size has. And I have him from time to time come and speak, and we'll do that again soon. Speak to the other providers, because you can hear it directly from the horse's mouth. Hey, what's the secret sauce? What moves the needle? His retention rate, by the way, his turnover is next to nothing as well, right? And he pays a little more than market, but it's not the compensation. It's the platform and what he's built there, and you can do that. Conversely, there's another business. I'm definitely not going to say this name. Their claim rate is 3 times higher. They're the number one in the industry, 3 times higher than the next closest one, right? 3 times. So that's telling you something, that you control a lot of this. You can control your platform, and really, without even knowing it, right? Not even realizing what you avoid some great things. Some terrible things, not great things, terrible things. Okay, so then once you have the policies and procedures in place, you want to train, make sure your managers understand what the rules are and your employees understand. And then you want to check periodically by spot checking payroll, time, entries, talking to folks, right? That it's working the way it's supposed to. It should be a living, breathing thing that is adjusted as the law changes, right? And as needs arise. And then I mentioned arbitration, absolutely critical. These are the policies you should have. I'm going to spend just a minute telling you about one of the things that we do. I know a lot of you subscribe to this already, but POSH, our Pulsinelli Online Solutions for Home Care, is designed specifically for this, for those that have a limited legal budget. You're not going to hire me and work with me directly. right? Because I'm too expensive, you may say. I say it's worth every penny and then some, but we can debate that for another time. But we give you templated materials that address all of these issues. They're industry specific, they are state specific, they are city specific. Kendall O'Kane on the call is the one that demos this. If you would like a demo, I'm just show you how it works real quick. This is an example. There's these guides that we update. You see this one was updated in February. We update these guides as the law changes. It tells you what the federal requirements are, the state requirements, and if there's a city requirement, like in Philadelphia, for example, with respect to the Domestic Worker Bill of Rights for Philadelphia, we will tell you that. And then you just click on this thing where it says click here for the document. We talked about how non-solicits are state specific. This is an example. You click on it, you get the template, right? It has been vetted by lawyers. It is for your business. You just have to fill out your information and presto changeo, you got all the stuff, right? You're trying to make it as easy as possible to be compliant. This is just an example of one state, New York, that does happen to have quite a bit of state law and some of the materials that you get in New York. If you are interested, and arbitration, we have a great arbitration program that works in every state. There's one unique and special for California, and it's not just the agreement, it's all the ancillary documents that go along with it, like FAQs and the like. So I really, really want you to have a strong arbitration program. There's been some recent changes to the law around arbitration and sexual harassment claims. So you want to make sure you've got a carve out, whether you're using ours or someone else's, make sure it's vetted and you're ready. And what's happening with sexual harassment claims is some lawyers are using sexual harassment claims to pull class actions in for wage hour purposes because you don't have a carve out and the law requires that you do. So if you haven't updated your arbitration agreement in the last year or so, have it updated, have it reviewed. All of this work, because we do it in such volume, isn't particularly expensive. So happy to help you. I think we've got a poll up now. If you would like us to give you a demo of Posh, just say yes, and Kendall will reach out and do it for you. Again, I know a lot of you are already subscribing. And then let's make sure we get to the other poll. I think I can just close this now. Is that right, Kendall? Or do I need to launch it or something? I'm terrible with these polls.
No,
it's
you're
launched.
good.
Okay,
It's
so
launched.
let's get to Scott's and then we'll get to your questions. And I'm happy to stay a few minutes over. I know we're right up on the hour, so if you got to go. But we do have some questions and I want to answer some of them at least to make sure that you're getting your money's worth. And that by money, I mean time. Okay. One other thing is we do have a relationship with Care Time where you get a discounted subscription to Posh if you utilize the code LiveTech0822. And if you would like to learn more about Care Time and all the wonderful resources that Scott highlighted earlier, please answer this poll. Would you like to see a Care Time demo? Yes or no? And then are you interested in learning about the connected care service partners, one of which is us? So they're pretty good. So answer either of those. And now let's turn to your questions. We can leave that poll up for another minute or two and start banging them out. All right. So we're going to go in rapid fire here. I have a full disclosure. I've not seen them yet, so I may pull the hook on a couple of the questions. But I will spend about 10 minutes here answering questions if that's okay with all of you. And again, if you got to go, roll off. All right. We are continue to be harassed by the ERC folks, headhunters, promising gold at the end of the rainbow, even though we've already claimed them through the CPA, who used a very stringent process. Getting old, is there anything we can do? Yeah, so there are a lot of these folks that there's like I said, there's quite an interest because it's very lucrative for them, and some are charging 10%, some are charging 15% of the total amount, some are charging even more than that. If that's your arrangement, or if you haven't entered into such arrangement, so What this person's saying is, hey, we worked with our accountant who was very qualified and was able to get us set up, right? So there's nothing wrong with working with those vendors as long as you're truly qualified. But like I mentioned, just like this provider did, you should have an independent source other than that vendor, you know, determining that you're qualified and then making sure that you have the evidentiary support for that qualification to protect against an audit. Next question, remote workers such as quality reviewer for medical charts serves in the US. How does that affect regional limitations with quality review company to another quality review company? I don't think I'm understanding that one. So I wonder if what we're asking there is about the non-compete, because you're asking about regional, that's what it is, regional limitations. So you've got somebody that's a quality reviewer and they're doing medical charts all across the country. How do you deal with any regional limitation there? One of the ways that you can do that is to limit the restriction in a restrictive covenant, right? Limit the restriction to those that the individual has been in contact with, right? As opposed to saying, you know, it makes sense if you are a restaurant or it's a caregiver, you won't, caregiver is a bad example. As you know, an executive, you won't work for a competing agency within a 20-mile radius and all your clients are in that 20-mile radius. But if you've got somebody with a national reach, then maybe what we're looking at now is, hey, the people that we introduced you to, and particularly over the last year, those relationships that are fresh, you can't go soliciting those same people. Next question, can we get templates of non-solicitation forms on Posh? You can, not for free, you got to pay the subscription cost, but the subscription cost is far less than having an agreement like that drafted by an attorney, because it's basically a cost share program across the industry. And it's going to be a higher quality than what you're typically going to get, because it's been vetted typically by attorneys that really know what they're doing and that have enforced those kind of agreements in other contexts. The next question, and I think this is about the non-compete, does this toss liquidated damages clauses for clients that take our employees and hire them privately? Does it eliminate them? So that's what I was saying earlier. The non-compete, that's our concern, is that the FTC's ban will be applied. And I know the HCAOA issued comments to the FTC explaining, hey, in this industry, clients sometimes take caregivers away, and that's not a non-compete. That's not the same thing as a non-compete. So what you should do, unless you're in Connecticut, is shift liquidated damages provision in your client service agreement, shift it away from damages or a penalty, I cannot do this, to a, if this happens, there's a charge for it, like a headhunter and a placement fee. We can charge you a lump sum fee up front, right? If you want to hire this caregiver, or we charge this way. And we get our attorney's fees if we have to come and collect, right? And then that gives me the leverage I need to call that client and say, hey, that the amount right now is $15,000. If though you don't pay this and we have to you enforce it and go to court, then it's going to be $15,000 plus my hourly rate. And you know, who knows how long it's going to take, so you might as well do it now. We are really, really successful in getting clients to pay when you've got that additional provision. If not, what the clients will sometimes do is assume you're not going to hire a lawyer, right? You're not going to spend time hiring a lawyer that's going to cost you more than the provision. The other thing is that dollar amount really needs to be tied to your actual costs and the actual volume, right, of work you're doing. So, you know, just be aware of that, right? If you just pick a number out of the sky, this is one of the problems that we're having with the DOJ in California, is they're saying, well, where did you come up with your number? What's the basis for that number? And the DOJ is thinking of traditional home care services a lot like home health. They say, well, it's just a periodic, you know, limited relationship with just short visits. And we're saying, no, that's home health. And home care, the relationship is often long. And here is the data right, to back it up of what a typical client is worth. And then here's the data on our overhead costs for background checks and training and everything else. And so you want to tie your number to that, and then you also want the number to be high enough that it serves as as an disincentive, and you should also tie it to each individual caregiver. I've had situations where somebody say, well, that's the total amount, right? And they hire away 3 caregivers, right? So you wanted to really specify that you're talking about at a per caregiver level. Next question, we're fans of Posh, and we recently had to utilize the direct hire fee section of our client service agreement when a client forced our hand, and a simple copy of that with a certified letter. The client took it to her attorney, and 2 days later, we had a check in the mail. All right, worked perfect. We have also started a form that the employee signs that states if the employee chooses to work independently or moonlight, then that situation will be referred to Adult Protective Services to ensure there isn't any type of exploitation for the safety and well-being of the client. Is this acceptable in a legal respect? I happen to know that this individual is in Alabama, which is highly slim on state law. I think that would be okay as long as you're not using it as a punitive mechanism. If it really is focused in and within your rights, the healthcare regulatory rights, to offer protection on behalf of your clients, I think that's a solid idea. Very creative. I like it. Next comment. This is more of a comment. Oh, something just new. You guys are asking questions faster than I can answer them. I haven't made any progress. We still have the same queue as where we started. I love it. That means you're paying attention. Okay. Let's do a couple more, and then we'll cut it off. For us, a caregiver working for a client outside of scheduled hours has come up as a liability workers' comp issue. So we write them up for going to a client without being scheduled, whether they are the current active caregiver for that client or not. We also have a policy against accepting other gifts and forms of payments from our clients. I feel like that's different than the policy that would constitute a non-compete, but essentially creates the same type of policy, at least while they are actively employed with us. Good. Those are all very good points. And one case that I've seen a lot of recently that I think you all should be aware of and think about is driving claims. And why I'm mentioning it is the workers' comp and the liability. We've had caregivers in their own vehicles, right, leaving shifts. I've got this case in California and another place. They're leaving a shift and they hit somebody or something happens, and you would think that they're on personal time. And there's policy limits, but these are cases that are above the policy limits, what they're asking for. So serious injuries. And the argument is that the agency should be responsible because it's their worker, even though the worker is outside of typical hours. And sometimes the argument is, well, the worker was picking up groceries for the client, sometimes not. And I've been surprised at some of the way some of the research has come back that is a viable claim. So I think we need to put, we have on Posh driver agreements and limitations of liability and all of that for both situations where the caregiver is driving the client's car or transporting the client in their own car. But I think we just really need to watch out. That's been a recent type of claim that in my history I hadn't come across it that much. All right, couple more. One on ERTC. If we used one of those firms who charged a percentage and haven't paid it yet, do you have any guidance on negotiating the rate, or what happens in the case that the IRS comes looking for that money? That's a really good question, because one of the things, I don't know if you've seen, like one of these vendors was actually rated by the IRS early on in the process, and it happened to be a vendor that was being promoted by some of the home care associations and everything. So they're very active with our business. Now that raid was about a different credit program, not ERTC. But the concern is that, let's say that everybody's paying the vendor up front, a pretty high percentage, right? With the expectation that they get their money, right? And the vendor has said, look, if you don't get your money, we'll pay you back, or we'll defend you or whatever. And then the IRS goes after that vendor like they say they will, right? Is the vendor going to really be able to defend you, right? The vendor's probably going out of business, right? So we do have a attorney on staff that evaluates those contracts and helps you determine, I don't know which vendor you're talking about, but helps you determine whether you can get out of the contract, whether you can renegotiate anything, or if you're kind of hooked. And obviously the fact that you haven't paid anything yet is very helpful, right? Because you still have some leverage. So if you'd like to talk, that's a different kind of attorney. That's one of our contracts lawyers, but he's looked at several of these vendors and be happy to help you if you need it. All right, let's see if we can get, well, there was a question about the white paper. The white paper is in the Q&A link, so just follow that link. If you're a POSH subscriber, it's also there. Let's see if, let's get this one. This one's a little bit of a cheat because it's a 5-part question. Is there a top 5 violations that the DOL sees in home care agencies? So let's real quick cover this, and then others who have questions, I'll try to follow up with you. I've got to travel the next week or so, but we'll try to get to you. One question was, are we in Connecticut? Yes, we're doing a ton of work in Connecticut. We're doing lots of work around the DCP audits, which are going haywire. They're going crazy. You're probably aware of the legislation pending in CT to get out from under the Connecticut DCP, which change how they're analyzing the marketing concerns that they currently have, how agencies market. So yes, we work in every state, and a lot of work in Connecticut, but a lot of every state. We have specialists for pretty much everything. There is a live-in agreement on POSH. There's a type of live-in agreement for each state. There's 13 hours, 16 hours, and there's also the ability to modify for a true live-in scenario. But let me get back to the question I promised. Top 5 violations that the Department of Labor sees in home care agencies. It's just a great question. That's a great question. So there's been a big, I don't know if I can get to 5 of the top, but a real focus on-call practices lately. And I'm going to do a program, one of the next industry programs. It probably is not this one coming up, because we're focused on the CMS access to care rule, the 80-20 rule. Everybody's going crazy about that for the Medicaid waiver. So we're going to have a real dedicated panel to talk about that issue. But probably the next one after that in December, we'll focus on-call, because nobody's doing on-call right. And the DOL is picked up on that, and they're looking at on-call. They look a lot at exemptions, particularly around your coordinators, care coordinators, right? Or schedulers that aren't really supervising caregivers. They don't have the ability to hire and fire or discipline, but they're coordinating caregiver-client relationships and the schedule. Those positions are typically not exempt, but sometimes classified as exempt. So the DOL is looking at that a lot. They look at travel time quite a bit. They really focus in on how we pay overtime and regular rate issues, where you may be paying rate in effect, pay overtime right at the rate that they're working at the time, instead of that weighted or blended average, or you're not including all the premiums that you have to, bonuses, on-call premiums, into the regular rate for overtime purposes. And live-in, they look at live-in, and one little piece on live-in. Those of you who say, live-in, I wouldn't touch it with a 10-foot pole because of all the litigation. Live-in is not a hard program to run. You just have to know how to do it. You have to set it up correctly. And if you set up your live-in programs the right way, with the right tracking and the right kind of agreements, you are not going to have live-in issues. The reason people have live-in issues is they're living in the past and paying day rates, or modified rates, right, where they're reverse engineering rates, or they're not tracking their sleep and meal time. They're not using the right mechanism. I like just a traditional timesheet, which is available on Posh, to deal with live-in. But you live in, you should not shy away from doing live-in. Just understand how to set it up. Live-in isn't going anywhere, and it's extraordinarily profitable. So just vet your live-in program, make sure it's set up right, and it's easier than the hourly day-to-day stuff. I promise you it is. All right. So thank you for your time. Thank you for your attention. If I didn't get to you, I will really, really try hard to later. And if you need anything from me or our team, just reach out. If you want that demo, reach out to Kendall. If you need legal services, contact me and we'll get you taken care of. We love you. We'll see you next time.
Thank y'all. This concludes today's webinar. A recorded version of the presentation will be available on Polsinelli Online Solutions for Home Care within 5 business days. If your question was not addressed live, we will contact you after. And if you did not submit a question, please feel free to at onlinesolutions@polsinelli.com. Thank you so much for your participation and have a wonderful day.
And thank you, Scott and Care Time, for the opportunity.
Our pleasure. Take care. Safe travels.